So once you have your guardian or custodian lined up and you have your idea about reunification not being viable with at least one parent, Jennifer is going to talk about exactly how you go about filing in family court. I want my water though.
Hello. Okay, great. So now we're ready to go to family court. You've determined who your custodian is going to be, who your guardian is going to be, and you need to know now what to file, what court to go to. So one of the first questions that we usually get is, I have a custodian, but they're undocumented, so I don't think that they can be, they can't file for custody for this child in family court. That's not true. A guardian or custodian can be undocumented. The family court has jurisdiction over a person no matter of their immigration status. So that's just one important thing to keep in mind. If you go to family court, if you send the child, let's say, to family court and a custody case or guardianship case has been filed, they will be assigned a 18B attorney or a lawyer for the child who is there to represent their interests. So that's also something to keep in mind. But a child does have a right to their own attorney and to choose their own attorney, and that's in the Family Court Act. So you could go to family court saying that you're the child's attorney, and you should be able to represent them. There are some courts in the counties that dispute this issue, and they will actually appoint a panel attorney even though you're going in as the child's attorney, and sometimes you're allowed to co-counsel with that panel attorney. I don't know if you want to. Oh, a panel attorney is just an attorney that works in the court that are assigned to the children. It's a child's lawyer. Okay. So who can file the petition? A guardian or custodian can file a petition pro se, but if you are working with a child that's over the age of 14 and you're doing a guardianship petition, that child can actually do a self-petition and say that they want this person to be appointed as their guardian. So I know some attorneys prefer for the children, if they're old enough to do the self-petition, kind of just to keep the boundaries in line and not have to help the guardian or custodian fill out that application while they're representing the child. So that's an option that you can have. So what do you need to file? If you are doing a custody case, you just have to fill out the custody petition, which is GF-17, and all these forms are on the family court website, so you just go to the website and get the form, make sure you have the most updated one, and with that form you attach a birth certificate to it. For guardianships, there's a lot more forms that you need to fill out. You have to do the guardianship form, and it's a form 601 if the guardian is doing the petition. If the child is doing the self-petition, it's 61A. The guardian also has to sign an oath of guardianship and a designation of service, which is form 62. And then there has to be either a child's preference, which is basically the child is saying that they want this person to be appointed their guardian if they're over 14, and if they're over 18, it's a consent of the child, and that's form 63. They also have to complete a state central registry form, which we call usually SCR clearance form, and this is where people kind of freak out about, because the guardian and anyone in their household over the age of 18 need to provide the court with the last all their addresses for the last 28 years. Okay, so I don't know where I've lived for the past 28 years. So this, I think, is like what kind of complicates the process a little bit. It's really important that this form is filled out correctly and there's no gaps between the dates, because the clerks will return the form and you won't be able to go forward in your case. The judges won't get the reports and your case will keep being adjourned until those forms are correct. And what that does is it just basically checks that those addresses and names don't show any abuse, neglect, findings against the people who live in the household. Do you have anything to add with that? So filing procedures, we listed what they are today. I say what they are today because they change all the time. So if you are working in a court that you haven't been to in a while, I suggest that you call the clerk and just make sure what the best way to file. Usually in Nassau, Suffolk, Westchester, and the outer counties, it's okay to mail in the application, and then they'll send the petition, and they'll send you a date, usually 6 to 8 weeks out. In the boroughs, you usually have to go in person to drop off. You cannot mail it in. In Manhattan, you definitely have to appear that day. When you're filing the petition, you will see a judge, so it's very important that you're prepared to stay there probably all day long because it is not a quick process, and that you go with your client to court. I will note that in Brooklyn, they have this new rule now in guardianship cases that if the service is international service, you're going to have to stay and see a judge, and you can't just drop it off. So also be prepared in Brooklyn for now to stay there all day. So what happens when you first appear? And this is whether you're appearing for the first time when the day you're dropping off the application, or whether you had gotten a return, you dropped off the application and they told you to come back. The first thing that they're going to ask the guardian or the custodian is whether or not they want an attorney. If the guardian or custodian says they want an attorney, they'll do an assessment to see whether or not the guardian or custodian qualifies for an 18B attorney. If not, they will adjourn the, they may give the attorney right there. Sometimes the 18P panel is in the back, but usually they'll just adjourn the case, and then that guardian or custodian will be contacted by their attorney. If the guardian or custodian doesn't qualify, then it would be up to them to get a private counsel the next time they come back. Of course, they can always say that they don't want an attorney and just appear pro se. The next thing that they will check is whether or not service has been completed if you had some time before your first appearance. If it's the first time that you appear, they'll order service and tell you which method you will have to serve.